I'm Michelle Kenny, one of the attorneys with GAPS Legal. We've created a series of short videos we've titled, I'm Fine. The future will happen whether I plan or not, to educate you on various estate planning documents. Our hope is that once you better understand the purpose of each document, you will consider proactively planning instead of leaving your decisions in the hands of the state of Florida. Let's get started. An advance directive is simply a directive that you're making in advance of the time of need. So just using the basic definitions from the words. A designation of a healthcare surrogate is under Florida law, you naming an agent to make medical decisions for you if you are ever unable, or otherwise authorizing an individual to speak with your medical providers. That document can be made effective when you sign it, or only at the time when your doctors determine that you're unable to make those decisions for yourself. It's a document that should be signed in the presence of 2 witnesses, and your surrogate cannot be a witness. One witness must also be neither a spouse nor a blood relative. So there are certain provisions under Florida law that govern the specifics of the document and how it needs to be signed, what sort of provisions might need to be included. So what happens if you have not executed an advance directive or you haven't designated a surrogate to make decisions on your behalf? Well, then Florida law determines in an order of priority who your decision makers will be. They may or may not be the people that you agree with in the order of priority that they're listed. A legal guardian is in the first position. Then if there is a spouse, they would be next. Any adult children, and if there's more than one adult child, then a majority who are reasonably available. Next would then come a parent, then adult siblings. Again, if there's more than one sibling, it would require a majority. Any other adult relative, a close friend, or a clinical social worker selected by a bioethics committee. So again, Florida law has a provision under the healthcare proxy statute that will name your medical decision makers in the event that you have not executed an advance directive. This may or may not be an order that you agree with. The proxy does not also apply in all situations. What do you need to do if you want to be in control of your own decision making? First, start with discussing with your family and friends what you would want, what you wouldn't want regarding your medical care. Making sure that your loved ones know what those decisions should be if you're ever not able to speak for yourself are critical to making sure your wishes get carried out. You need to make sure that you have determined who those trusted friends or family members might be and in what order you might want to name them. Seeking the advice of an attorney to assist in the preparation of the appropriate estate planning documents would come next. The attorney can draft documents that clearly state what you want, who you want to act on your behalf. GAPS Legal is available to help with all of your estate planning needs. You can reach us through our website at gapsattorneys.com, by email to info@gapsattorneys.com, or by phone at your convenience. The office number 954-315-4801.